I think the appearance of new counsel on behalf of the Wayfarer parties is connected to the filing by the New York Times on Friday. Let me tell you why. Recall that the Wayfarer parties sued the New York Times for defamation, and on June 9th, the court dismissed the New York Times, meaning dismissed the claims the Wayfarer parties had against the New York Times for defamation. It did so without leave to amend, meaning that the Wayfarer parties could not amend their complaint against the New York Times. Therefore, those claims are gone forever against the New York Times. Rule 54B of the Federal Rules of Civil Procedure governs when a order can be final where a case involves multiple parties. So here the New York Times is saying, while there's an ongoing action, there's other parties, other claims, all of the claims between the New York Times and the Wayfarer parties are done and complete. And there's really no reason to delay issuing a final order on behalf of the New York Times for the rest of the case to continue. Meaning that whatever happens in the rest of the case has no bearing on the New York Times. For that reason, they seek a final judgment. One of the arguments that they make for the reason why there's no good reason to delay issuing that final order is that there's nothing to be gained by delaying. When a final order is provided to a party, that initiates the timeline for when a party can appeal that decision. That becomes an appealable order. So what the New York Times is saying here is that even if the Wayfarer parties choose to appeal that final order against the Wayfarer parties on behalf of the New York Times, if that appeal were to go up to the Second Circuit and get reversed back down to the trial court, then it's in the interest of justice to expedite discovery on the claims against the New York Times. So essentially they're saying the faster that you give us the order, the faster an appeal could happen and the faster we could get to the discovery if it were to go down that route. Now, there's a lot of ifs there, but essentially what they're seeking for is the timeline on appeal to be commenced. They don't want to wait for trial to end here with all the other parties. They want the order now so that their clock starts ticking, Wayfarer's clock starts ticking, so that if they wanted to appeal the order that was issued with respect to the New York Times, they would have to do that now. So I imagine that we will see some kind of opposition by the Wayfarer parties that says that this is unduly burdensome on them and that they can't be fighting an appeal while they're fighting the merits of this case, given that there is an ongoing dispute and that's very much in motion. So we will probably see an opposition filed by the Wayfarer parties about why it's beneficial to everyone if we were to wait for all of this to be said and done. In any case, if the judge grants this, which is likely to happen, that sets off the timeline for the Wayfarer parties to appeal. So that's when the new attorneys that we have seen appeared on the docket, that's where they come in. So they have appeared here, they are starting to create that record, and that record would be used when the Wayfarer parties, if they decide to appeal the order. So if the court grants this order and the time clock starts for the time that they have to appeal, then that's when these attorneys who seem to have a ton of appellate experience, that's where they kick in and that's what they will be working on. So that's what I think is the reason why we are seeing these newcomers come onto the scene, because they anticipate that they'll have to work on an appeal simultaneous to having to litigate their defense in the Lively case. These people are really well suited to represent Wayfarer on an appeal. Alexandra Shapiro clerked for Ruth Bader Ginsburg, which is no small feat. Both Alexandra and Jonathan Bach have extensive experience in the appellate courts and litigating, come from very, very prestigious law schools, and have handled numerous high-profile cases. And judging by the appellate work of Alexandra Shapiro, I think that that's where Wayfair is going with this, is that they are likely gearing up for either an appeal of the order against the New York Times or a future appeal in this case. In any case, having them on the panel of attorneys preparing in the background for that scenario is probably where this is going. There's some speculation I've seen online about, does this mean something about Van Zandt? I don't know. We haven't seen any filings about Van Zandt or Wayfarer's use of Van Zandt in this case, and until we do, that's not something that we can easily speculate about. But these people would also be very well equipped to handle anything that has to do with Van Zandt. Preparing for an appeal while litigating is a very smart strategy, especially where there are a lot of parties, there are a lot of issues, there's a lot of concern for how the outcome of this will lay out. Having experienced appellate attorneys on your panel of attorneys is, if you can afford it, is exceptionally good strategy to have, because they have insight into what kinds of things can create an appealable issue. So I think this was a good strategic move on the Wayfarer Party's part.